Counsel for Ms. Hernandez,
Paula White for Ms.
and
Hernandez.
counsel for Mr. Cabrera.
Ashley Sosa representing Mr. Cabrera.
May lower your hands, and counsel for the Attorney General's office.
Yes, Elvira Villarreal for the Office of the Attorney General.
And Ms. Villarreal, what are we here on today?
Yes, Your Honor, we're here regarding Attorney Sosa or Mr. Cabrera's request through his attorney regarding a motion to refer this case to district court. And Your Honor, at this time, the state's position regarding that is the objection was filed timely through an answer and counter petition. But the state is requesting that Your Honor hear this case for a temporary order hearing before it actually gets referred to the district court. The objection was for the final trial to be heard by the presiding judge. And it doesn't mention anything regarding the temporary order at this time. There are no settings set in the district court regarding any type of temporary order hearing. I do understand that Attorney White also has her position, and she has mentioned that she is she's representing Ms. Cassidy Parvin, now Cassidy Hernandez, on a limited scope basis. So that is the limitation that that's being presented before Your Honor regarding Attorney White's representation. And that is somewhat of a summary of what's the status of this case so far. The state is ready, Judge. So that is our position. And I have no objection to the referral to district as there is conservatorship issues. The only thing is I would want a temporary order set of some sort before it gets transferred over.
Okay, Ms. White, I guess, would you like to explain your position?
Yes, Your Honor. So
Okay.
I was retained by Ms. Hernandez to represent her at this hearing only.
Okay.
So I was only contracted for this hearing just to make sure that she has some type of representation. During the pendency of this hearing, I did get notice of the referral. I talked to Ms. Hernandez about it, let her know what it meant, let her know how it affects the case, if any. She objected to it. I let opposing counsel know, and as I stated to her, it's totally up to her at that point. I can't make that decision for her because I'm not contracted to do or retained to do so.
Okay.
May I, Judge?
Yes, Ms. Sosa.
I think the one thing that we really need to establish is that after this, that the Attorney General and I will have the authority to speak with Ms. Hernandez if Ms. White is not going to be on here, because her appearance is for the entire cause of action, and that limits me. I don't feel comfortable talking to her while she has an attorney retained. So I guess if we can have like an official ruling on that, or I guess we would have a stipulation potentially.
Yeah, yeah. Okay, it's very unique in family law to have a contract like that. So I understand your concern, Ms. Sosa, and I am a little concerned and a little confused as well. So I understand where you're coming from.
With regards to the Attorney General's position on having a temporary order, I don't know that I'm opposed. I just found out, and presumably it'll come into evidence that Ms. Hernandez was just arrested this morning for family violence. So if that has happened, I think we need a temporary order to ensure the safety of these two children.
Well, arrested and charged are two different things. The circumstances to that may be a little bit more sketchy than just being charged.
So I don't know if that changes the position of having a temporary order, but like I said, if there is a pending charge for family violence, it may be necessary that we either have the hearing today or have it very soon. And I can already reach out to, the court to find out when we could have a hearing.
And at this point, no one has filed any emergency pleadings or...
It just happened.
Okay. And nothing emergency was happening before whatever happened today or yesterday. Okay.
Yeah.
Okay.
No, yeah, they were doing a 50-50 up until recently.
How recently did that stop?
I don't think it stopped. It hasn't stopped.
At Ms. Sosa, are they doing a 50-50 right now?
That's not my position.
Okay.
They're doing a 50-50 right now. Yeah, someone can say something.
Okay. I am going to refer this case to district court. I'm not going to do a temporary orders hearing today. I think it's going to be an extensive hearing, and I don't want to waste judicial time. There's some serious issues in the case. And then with the issue of Ms. White's
I will actually be filing the withdrawal today, Your Honor. Well,
Okay,
I'll
that will
just-
help clarify things.
Okay.
Okay.
No, I'll be
yeah,
sending it to
file-
the, to Ms. Hernandez for signature. We talked about it, so she's aware that I'm withdrawing after the hearing. So there's no confliction between the client and I.
Okay, and Ms. Hernandez, you recognize that Ms. White's going to be withdrawing after this hearing?
Yes, ma'am.
Okay,
And
Um,
Judge, just one thing, just for clarification, just for everyone. So Attorney White is still on, so all notices regarding any type of proceeding will be sent to her until that withdrawal is actually signed by the judge.
Understood.
Just so that Ms. Hernandez is clear regarding that as well.
okay. Yes, so all notices until that gets signed will go directly to Ms. White since she is technically represented. Please get that on file as soon as possible.
Yeah,
You
I'll
might
get it to the
want to
client. Okay.
contact the district clerk's office to push it along as well. If it gets to me, I'll sign it. It might go to the referring court though, in light of the referral. I don't know. It's
I'll
a
let them
mystery.
know. I'll when I speak with them, I'll let them know.
okay. And I'll bet some things come through to me super fast, like sometimes the same day, and sometimes it takes a few days. So I think it depends on what's going on with the district clerk's office, how quickly that will get to anyone. So
I will let them know. Thank you.
Okay.
Thank you, Judge.
Thank you. So yes, you're all excused for the day and good luck with everything going forward. And yeah, you're free to go for the day. Thank you all.
Okay.
Thank you,
Thank
Judge.
you.
Before we begin, there's a few housekeeping items. Even though we're on computers and devices, this is a hearing and we treat it as such. No one should be recording this proceeding. Speaking in civil tones with one another is expected. Generally, we take testimony in court, and so one of you will be asked questions at a time by the Assistant Attorney General. And if you're not the person being asked questions, unless you have a legal objection, please don't interrupt or answer for the other person. Just wait till it's your turn to speak. I do want to hear from both of you, but it can't be a back and forth conversation. So just wait till it's your turn. Also, please know I'm not with the Attorney General's office. You've obviously spoken with them a few times about your case, because it's not your first time here in court. But please know, unless it's in the court file or it comes out during this hearing, I don't know about the issue or anything. And so don't assume that, oh, it's kind of icky. I'm sure like Mr. Fethern will just tell the judge behind closed doors. She can't do that, and she won't. So if there's something important out there that's relevant to the issues in your case, please be sure to say it during the hearing.
Thank you, Your Honor. We are proceeding with the original petition and suit affecting the parent-child relationship. And there were temporary orders after a hearing was held on June 26th, 2023. We'd asked the court to take judicial notice of those temporary orders.
I do take judicial notice of the temporary orders. It was a managing possessory conservatorship. If there's someone in a house with noise, if they could maybe go to a place with less noise. Exchange was with Carol Warren or Kathy Curry. Obligor provided health insurance. Child support was set at $9.44 a month. I take judicial notice of the temporary order.
Thank you, Judge. We are going to be asking for a modification, just additional temporary orders regarding the possession and access today.
Is that an agreement or is that a contested issue?
Your
Yes,
Honor,
ma'am.
I'm bringing it to you because you made these specific orders for supervision and locations. So,
And I'm not questioning why you're here. I'm
oh,
honestly,
sure.
if it's an agreement or if it's a hearing, just so I know how to, I listen differently. And so
Oh, sure. To some degree, the parties have been, they had been exchanging the child at a different location than what you ordered, Judge. And it's agreed that the visitation does not end at Sunday at 3:00 as you ordered, but it's been going through Monday morning. So,
okay. Since we're focusing so much on what it used to be, and I honestly don't have it memorized, let me get that page up so I can kind of see what you're talking about.
thank you, Judge.
What page was that on? Was it at the end of the order?
It is, yes, Your Honor, 16, page 16 is the modified possession and access
Put it
order.
in two places, so it's hard to follow.
Yeah, and then on page,
That was not my order.
on page 4, that's where the supervision is listed above the possession and access paragraph.
Okay. So what are they agreeing to now?
They are agreeing that additional visits are taking place.
Okay.
And the supervision is an issue not agreed upon. And the times and locations, the time Sunday or Monday, and the location of 2430 in
I'm
Texas
sorry.
City is not being used.
Do they have an agreement on what is being used, or is that in dispute when it will end?
Yes, Your Honor.
Location?
The
Okay.
daycare, yes.
And what time is it ending on Monday?
It's what,
Monday.
Mr. Fethern, is there an agreement on what time it ends on Monday, or is that part of the hearing?
It's part of the hearing.
Okay. Okay. Okay, so the hearing is purely on modifying the visitation.
Right, Your Honor.
Okay, they're
Yes.
not ready to proceed to final trial.
No, Your Honor.
Okay, you may proceed.
Thank you, Judge. I'll call Mr. Warren. And you understand that the judge previously ordered the exchange of possession of the child will occur at this.
Yes, ma'am.
Have you been using that address to exchange?
The first time we went there and there was no one there. It was an empty house. It was for sale.
Okay.
And
So where have you been exchanging the child?
the daycare each time.
Okay. What time do you go to the daycare on first, third, fifth Fridays?
There's on Fridays, about 4 to 4:30, anywhere from 4 to 4:30.
Okay. And when do you drop the child off for the weekends?
On Monday morning, between I'll say 7 and 10.
Okay. And how did this come about?
This came about because my mother went to the address on file that we're supposed to pick Easton up at, and it was vacant. We didn't know what to do at that point, so I contacted Kathy, and she had no idea about it. And also,
Is that Kathy Curry?
Kathy Curry, she stated to me that she had no idea about it. So that's
And
when
Kathy, I'm sorry. So Kathy Curry or Carol Warren were to be supervising the visitation. Is that correct?
yes, ma'am.
And have additional periods of possession and access by you. Are those occurring?
Yes,
Additional periods? Okay.
yes.
How
One
often?
time- how often? It's very random. One time, she needed somebody to keep him, and my sister was available versus my mom, so he came to my sister's house, and that's where I seen him. Other than that, we had him for a week here at my mom's house. We've had him double weekends in a row outside of orders. Just whenever she requests, she'll send it through her cousin. Can we keep him for the weekend or something like that? If it's not our scheduled dates, and that's how it is.
And I might have missed this, or it might have been implied, but all the visits you're doing, are they supervised by anybody? I don't see how they could be, but are they supervised by anybody?
Yes, every one of them are.
So you're picking up the kid. Who's with you when you pick up the child at daycare?
My mother.
Okay. And then
My
she stays
mother-
with you all weekend?
He's always, I now live at,
Okay, I don't know what that is, sir.
this is my mom's, the address on file, my mom's address.
Okay.
So, sir, you did live in Dallas, correct?
I did live in Dallas, and now I live at the home, my mother's home.
Okay. At 3,004. So all of the additional periods of possession outside of those set out in the temporary orders, those are supervised?
Yes. You said the outside of the orders?
Yes.
I mean, they're supervised, but at the same time, like if my mom goes to the store or something like that, I still got Easton here at the house with me. We all live here, so it's like it has to be supervised because she's going to be here regardless at her home. So yes, and then if it's not supervised by my mom, it's been my sister.
Okay,
And-
Siobhan Warren.
And maybe you're going to get to this, Mr. Fethern, but there were, and I don't even understand my notes. I could pull up my better notes. There were criminal charges between these parties. I don't know from who was the aggressor and who was not, based on the notes I'm looking at right now, but are they still pending and what has happened?
They're still pending.
What are they accused? Who of what?
I was accused of family violence, strangulation, or impeding breath.
And that's still pending, Mr. Warren?
It's still pending, yes.
And the other charge?
The other charge was sexual harassment, and it was dropped.
So, Your Honor, we will be asking for a reset of this for final orders, but because this possession and access has changed, we're requesting orders from you, Your Honor.
Okay. Does anyone know if that criminal action has any bond conditions or orders that involve Miss Lewis or the child?
It has nothing with the child. I am not able to contact or physically see Miss Lewis.
Does anyone have a copy of these orders?
Of the orders,
That you're referring to?
I don't have a copy with me right now. I think I had it the first hearing, but I will be able to email whoever I needed to email it to.
You may proceed, Mr. Fethern.
Thank you, Judge. Mr. Warren, are you making any specific requests regarding the supervision?
Yes, I would like for the supervision to be taken away, being that I've been asked to keep my son outside of the orders, and it's went well. She speaks highly of me being a great father on social media or anything else. So I just don't see the reason for a supervisor.
Would you ask that Siobhan Warren be allowed or ordered to supervise if the judge does maintain the supervision requirement?
Yes, I would like to add her if the supervision requirement is held.
And what is your mother's name, sir?
My mother's name is Carol Warren, C-A-R-O.
Who's Siobhan?
Siobhan Warren is my sister.
So who are you asking that would supervise if it's if I order supervision?
If you order supervision, I'm asking that it's my mother and my sister.
What about the aunt, Kathy Curry?
She's
So
not
can
on.
I speak on that part?
Ma'am, I'm assuming they're going to call you next. If not, I'm going to give you a chance to speak for sure.
Okay.
Mr. Warren, has Kathy Curry supervised any of your possession and access?
Maybe it was the first one when we had to go to the new location where she lives. Whenever the new location was established where Kathy Curry actually lived, we did exchange there, if I'm not mistaken, once, and that was
Okay.
at I'm not sure what the it's where her grandma stays. But I think
Okay,
that was at the beginning, way at the beginning one time.
were there any issues with Kathy Curry?
No, me and Kathy have a great relationship.
Okay. Are you asking for any additional modifications for the visitation schedule?
No.
Thank you, Mr. Warren. Your Honor, if I may call Ms. Lewis.
You may do so.
So the visits have been ending on Monday morning at the daycare rather than 3 o'clock Sunday as the judge ordered, correct? Is that correct?
Yes, it has.
Okay. And so the exchange location has been the daycare instead of the 2430 address set out in your orders.
Yes. Originally, when we first had the orders, I was unaware of my aunt moving out of her house into the senior facility that she's in now. But after she moved and everything, there was never a drop off. The first visit that was with the court order, me and his mother met in the parking lot of what was that? Papa's. It was a meetup and a drop off there. We've never have met at my auntie house ever. So I don't know where that even came from. And then after those drop offs, there were issues with us being able to like even be cordial or civil. So I brought it up on myself to request that we do pickups on the Fridays from school between 4:30 and 5 and drop off back at school on Mondays at their earliest convenience. And that has been working out well.
So the visitation has been smoother than it was in the beginning, correct?
Yes, visitation has been smooth. The only reason I've asked for the week is I recently just got accepted into the nursing program. So I needed a little bit more help than the first, third, and fifth of the weekend. But it's only been twice that I've asked them to keep him outside of the first, third, and the fifth weekend, which was that week he spoke of. After the weekend that they had him, I asked if they would like to keep him until that following Friday. It was agreed on. And then as well as this weekend coming up, which will be the weekend of the 27th, which will be the second time that I've asked them to keep them longer than the outside court order. So it's like they have 2 weekends back to back. But other than that, it's only been 2 times I've asked so far. Yes.
So are you asking that the court allow additional dates for visitation?
Yes, when needed and if needed, because they've had issues.
Mr. Feston, I have a question. The original order that I signed, and as you stated, I ruled on, I guess, it says that it's ordered the parents may have possession of the child at any and all times mutually agreed to in advance.
Yes,
so are
sure.
they asking for specific extra time beyond what was ordered, or are they just wanting that language again?
I just want to confirm that was your intent, Your Honor, that they do have possession at other times that they agree upon. I just want a confirmation of that.
That's what the language says.
Thank you,
How
Judge.
flexible it is, that's way beyond 40 judges.
Sure. And I'm just asking that because of the specificity in your order and the fact that they're going out outside of it.
Specific in my order language, or it's not
Sure.
enforceable. So
absolutely, Your Honor.
okay.
Ms. Lewis, are you asking that the court to make a ruling on whether or not Mr. Warren's visitations continue to be supervised?
So that was never my ruling, or I never asked of that the first time. The judge, because of the court orders, because of the domestic violence ongoing case that was going on, she ruled that I had no control over that, like I've told Mr. Warren and Mrs. Warren over and over again, that was not I didn't ask for supervised visits. That was placed in order by the judge. So that's out of my hands. That will be up to the judge if she wants to continue or not.
Okay,
Sure.
hold
Are
tight.
you-
I'm gonna look up my notes from that hearing because it was in June. And I honestly don't remember details. Well, at the time, ma'am, he hadn't seen his child since January. And that was June. So something happened between January and June that you weren't even letting him see the child.
It wasn't me. They hadn't reached out. We hadn't heard anything from him until he got served with child support papers. And then that's when they asked to see the child. I never kept the child away from him. I had tried reaching out to him. His excuse was all the time, I can't talk to you. I can't talk to you. So my whole thing was, if you can't talk to me from January to June, you had middlemen like your mother, your sister. No one had reached out to me. No one had reached out to my family. That was the only reason I even filed child support, because it was from January to June that he hadn't reached out. He hadn't did anything financially for our child.
And Mr. Featherland, do you have a copy of any of the orders, the criminal orders?
No, Your Honor, it occurred in Dallas. If it was Galveston, I was going to pull it up.
Okay, and I don't have a copy from last time or this time.
Request to make a comment.
One moment, sir.
Yes, ma'am.
Yeah, we're submitted. Okay. Sir, before you speak, I'm trying to just figure out narrow this so it doesn't drag on and meander too much. So you basically both don't want supervision right now.
I don't have a problem with the supervision being lifted. Like, I've never,
Okay,
that
ma'am,
was never my.
ma'am, it was really meant to be a yes/no question. So the fact that it's not
Sorry,
to you
no.
makes me think you have reservations still, because not having a problem or wanting it removed are kind of two different things.
I don't have a problem with it being removed.
But do
no.
you want it removed? Because without having the paperwork on the criminal action, that's probably why I did it the first time, and I'm still a little nervous because honestly, people don't always read everything, and it's legalese, and sometimes people miss things, and I'm a little concerned. And quite frankly, when there's criminal actions pending, it kind of raises the hair on my neck that there are some problems possibly, and these are children at issue. And I don't want children to be hurt based on my negligence. So do you not have a problem with it being lifted, or do you want it? Do you think it's in your child's best interest that it be lifted?
Yes.
Are you sure? Because you took a moment and a deep breath.
Yes, it's in my child's best interest for it to be lifted. Yes, ma'am.
Has he ever hurt your child, or do you allege he's ever hurt your child?
Other than, no.
Was your child there when you claim you were strangled?
Yes, my child was there the entire time. My child was taking out my arms, putting in the thing while I was being abused, and he was crying in the background. So yeah, I'm sorry. It's a sensitive situation.
Yeah. Well, that's why
Request to make a comment.
you may do so, sir.
The allegations of abuse and anything.
And keep in mind, sir, you do have criminal charges pending against you. I'm not trying to get too into them,
I
but it's
understand.
almost being thrown around in this hearing like I willy-nilly ordered supervised visits, and it's a temporary order, and I usually don't do it unless I feel there's a reason. So but you're free to speak, but there are criminal charges pending against you, and you
Yes,
are
ma'am.
also free to take the fifth. Mhm.
Yes, ma'am. I have proof that my family has reached out. No, I haven't reached out. I have tried to reach out to her mom and this is between the time where I didn't see my son.
Okay, sir. So remove at this point, there are temporary orders in place. This is just whether they get modified or not today. This
Okay.
isn't final trial. I'm not going back. We already litigated once, so I'm not, but again, I felt like there was a lot of allegations of you just ordered this out of nowhere. And I usually don't. So I just wanted to see why before I say, oh yeah, no one wants it. Let's just remove it.
Well, I have proof that she's spoken of wanting to keep him away. I have proof of
Okay.
in that time period. So
Okay, but we're moving forward today. I'm not trying to completely move backwards. I just wanted to make sure there was a basis the first time I ruled for supervised, because I was getting the impression no one ever wanted it. And I just did it out of nowhere. So I just wanted to see where my nowhere was. So I could see if the situation has changed or if things, why I even did it.
well, it's just for the allegations that she went to.
Well, we lost her. So wait till she comes back.
Muted.
Okay, sorry, ma'am. He stopped talking when you left the meeting. And I was trying also to do that because once someone's not here, we can't continue. So that's why I was muted. You are back now. So you may continue, sir, with what you were saying before.
Yes. My only thing I just want to get across is, yes, there are allegations. Yes, she went forth and said whatever she said, but I'm innocent, and I do not understand how, if nothing has been proven in any type of way, how am I, restricted from something?
Well, and there's a reason this is a temporary order, sir.
I understand.
And so I'm not making any final decisions, and I didn't make a final decision last time either.
There's also a letter where she wrote that I did nothing of the nature. And I have that letter that she claimed that I forced her to make.
And I have messages that you were the forcer of that. But that's not what this court is about.
It's not, but but all of this explains a lot of what went into my decision. And I'm going to, if nothing else, and I'm not making my final ruling yet on anything, but I am going to order a parenting class for both of you today that you're both
Yes, ma'am.
required to take before final trial. These cases are very hard in 4D. We don't have ad litems investigating. We don't have psychologists investigating. And I get very limited information. I think we're all familiar with the cycle of violence, and sometimes people are pressured into things due to it. What's really going on here? I don't know. I don't know that the criminal court will figure it out. But there's a lot of red flags, which is why I made my initial order. A lot of red flags. And so that being said, I'm not trying to be a tyrant here. Ms. Lewis, are you truly comfortable with not having someone given that you're living with them, I'm not sure why you're opposed to the supervision right now on a temporary basis.
That's just me. If I wanted to take my son to the aquarium, or if I want to take him to anywhere, a Father's Sunday. I take very well care of my son, and I would like to be able to be with him and do things with him and not have to go off of my mom's schedule.
Ms. Lewis?
It can be lifted.
I hope this is the right decision for your child. I really do. I'll remove the restriction. And you're all agreeing to modify the pickup and drop-offs, to change it from. Mr. Fethner, did you have a proposal on that in terms of time? Did that worded?
Your Honor, Mr. Warren testified Fridays from 4:30. I suppose Friday at 4:30, and then Mr. Warren, what time can you drop off the child at the daycare?
Anywhere from 7 to 10. 10 is the latest that we can drop him off per the daycare.
What are you asking for? What time?
8 a.m.
8.
Okay. I'll modify the visits. So Mr. Warren will have visits at all times as mutually agreed upon as per the prior order. That didn't change. It will be Friday at 4:30 p.m. to Monday, the morning at 8 a.m. on the first, third, and fifth for the last order, with pickup and drop-offs at the daycare. And I am ordering parenting classes for both of them. They must take them before the final trial. Mr. Fethern, do you have a proposed date for final trial? Sir, do you know when your criminal trial is set for?
I'm actually waiting now for a response from my lawyer.
Mr. Warren, do you have a trial date set in the future on that criminal matter?
No, ma'am.
Do you believe it could be within 45 days or 90 days?
If happens, it could be within 45 days.
December 13th at 8:30, Your Honor.
Do you think it's likely to be in 45 days, sir?
Say again?
Do you think it's likely to be in 45 days?
Yes.
What date was that? December 18th?
December 13th at 8:30.
And I'm just going to remind you that the state does not represent either of you. You're both free to hire lawyers or consult with lawyers. And so we're going to have you go back to the breakout rooms and they'll prepare the order and they'll be sending it to you. And good luck with everything going forward. Please know nothing in this order prohibits either of you from taking any other actions you feel might be necessary to protect your child. If God forbid something happens, you're free to call police, CPS, any official you would normally file. Free to consult lawyers, as I just said as well. Okay.
Yes, ma'am.
Yeah, thank you.
Thank you.
And Ms. Lewis, you're sure you're comfortable? Ms. Lewis, you're sure you're comfortable with this?
Yes, ma'am.
And you're not being pressured into this?
No.
And myself. And I am sitting outside of Galveston County pursuant to Texas Family Code Section 201.1045. And I find that nobody has filed any written objections to proceeding in this manner. Appearances. As recently as September 11th of 2023, Ms. Mark was present in court when this case got reset for today. And she did sign that reset order with the Zoom code information. So I find she does have notice of today's setting. She was also present on July 5th, 2023, when the case was reset for her to provide information about insurance for one child. And so she made an appearance then as well. She also was present on April 12th, 2023, when it was reset to have service, to obtain service on you, Mr. Boykins. So she was present July 5th. Do you know why she is not here today, Mr. Boykins?
No idea.
It just seems strange because she's been an avid attender of all of these settings.
Yes. And Judge, if I may say, I did make a call to Miss Mark earlier today, but there was no answer. Actually didn't even ring. It sounded like a busy dial tone. So an attempt was made to try to get her to appear for today's hearing.
Well, she's okay. Okay,
Yeah.
okay, proceed.
Thank you, Your Honor. Your Honor, at this time, I would like to ask the court to take judicial notice of the motion for modification and the motion to confirm support of rearage filed January 9th, 2023, with the attached documents.
Okay, I take judicial notice of the pleading with the attached document being a portion of the prior order.
Thank you.
It shows,
Oh, yes.
Mr. Boykins was ordered to provide health insurance and set child support at $397 each month with a step down to $318. And it was signed by the court on July 11th, 2012.
Thank you, Your Honor. And with that, I'd like to call Mr. Boykins. Sir, what is your relationship to the two children in the suit?
Father,
And what are the names of the kids? And how old are they?
17.
Are they both 17?
Yes, ma'am.
In fact,
Twins.
they're twins, correct?
Yes, ma'am.
Okay. And sir, at this time, who does Cullen reside with?
Myself,
Okay. And how long has he been residing with you?
quite some time, some years.
And who enrolled Cullen into school?
I myself.
And when was the first time you enrolled Cullen into school?
I'll be lying. I ain't got my paperwork, but I sent some paperwork in, and I can't recall.
So from your recollection, let me ask you this. What grade is he in now?
He in the 12th.
Okay. Did he reside with you?
Yes, ma'am.
Did he reside with you this entire year, 2023?
Yes, ma'am.
Okay. And in 2022, what grade was he in?
11.
Okay. And was he residing with you when he was attending 11th grade? Mr. Boykins, there we go. Go ahead and state your answer.
Ma'am?
Was Cullen residing with you whenever he was attending 11th grade?
Yes, ma'am. Yes, ma'am. Somebody tried to call in on my phone and I denied it.
Okay, thank you. Now, in 2021, which grade was Cullen in 10th grade?
Yes, ma'am.
Okay, and in 10th grade, while he was in 10th grade, was he residing with you?
Yes, ma'am.
Okay, and in 2020, what grade was Cullen in?
He never failed now, grade 8.
So he was in 8th and started his freshman year of high school in 2020, correct?
Yes, ma'am.
Okay. And in
I'm sorry, what happened with 9th grade?
Ma'am?
Are you saying he skipped 9th grade?
No, ma'am. No, ma'am. No, ma'am.
No, Judge, he said he never failed. So in 2020, he attended 8th grade and 9th grade, since the end of the 8th grade year was in 2020, and the start of freshman year was in 2020, August of 2020.
Right. He never failed. Neither one of them failed no classes, no grade.
And in August of 2019, you enrolled Cullen into his junior high 8th grade year, correct?
Yes, ma'am.
Okay. And in this case, he's been with you since the beginning of the 8th grade year enrollment.
And what year was that again? I'm sorry, I'm trying to keep track of all this because I'm guessing I have to do math.
No, 2019, Judge.
Okay.
So since August of 2019, Cullen has been with you, correct?
Yes, ma'am.
And you've registered Cullen to attend school.
Yes.
Okay. And
I did it, or I had his mother to do it for me. I can't remember.
Okay.
On that
And
one.
at this time, Chloe, your daughter, who does she reside with?
Mother.
Okay. And she's always resided with her mother?
Yes, ma'am.
Okay. So you and Miss Mark, after the order was signed, split the kids. Is that right? You had Cullen and she had Chloe.
Right. That was by his choice, not by mine.
Okay. But
Yes.
you and Miss Mark agreed to that.
Yes.
Okay. And that is the change that's happened since the 2012 order. Is that right?
Right.
Okay. And at this time, so you were court ordered to apply for private health insurance for both kids. Is that right?
Right. Yes, ma'am.
And at this time, do you still have both children covered under your private health insurance?
Correct.
Okay. And what health insurance do you have for them?
Blue Cross Blue Shield.
Okay. Thank you. And that is through your employer?
Yes, ma'am. TCISD.
Thank you. And at this time, there hasn't been a modification as to the medical, correct? Because you continue to provide that support.
Right. Right.
Okay. And sir, you understand that in the prior order, you were still obligated to pay child support for one child. Is that right?
Yes, ma'am. Well,
So you were obligated to pay for two,
yes.
right?
Yes.
But in the event that there was only one child left, you had an obligation to continue to pay support. Is that right?
Right. They're still taking whatever out of my check right now.
Correct. And at this time, you had an opportunity to review the payment record on this case, right?
Yes.
Okay. And Your Honor, at this time, I would like to offer State's Exhibit A, which is the payment record for this child support case.
Okay. And Mr. Boykins, do you have any objection to me admitting the payment record as State's Exhibit A so I can look at it and see it?
No, ma'am.
Okay.
No, ma'am.
I am going to make that pay record State's Exhibit A. I'm admitting it into evidence.
Okay. And Mr. Boykins, at this time, as of yesterday, you still have an outstanding child support arrears of balance of $8,338.01. Is that right?
Correct. And they still take it out my check.
Correct. And at this time, there is some money on hold that hasn't been applied yet. Correct?
Correct. Yes, ma'am.
But you are requesting the court to give you some possession credit for having Cullen. Is that right?
Correct.
Okay. And are you requesting that possession credit go back all the way to August 1st, 2019 to the present day?
Yes, ma'am.
Okay, and we actually did a calculation of a proposed calculation for that possession credit, right?
Yes, ma'am.
And you had an opportunity to review that document as well.
Yes, ma'am.
Okay, Your Honor, at this time, I'd like to offer State's Exhibit B, which is the possession credit calculation for this case.
Okay, and sir, do you have any objection to me admitting State's Exhibit B into evidence, that possession credit calculation?
No, ma'am.
I'm admitting State's Exhibit B.
And sir, the difference between paying for 2 children and paying for 1 child is $79, correct?
Yes.
And so we gave you the calculation based off of the $79 difference since those periods of possession, correct?
Yes.
Okay. And that totals out to a maximum possession credit of $4,493.64. Correct?
Yes, ma'am.
And you're asking that that be applied towards the arrears and that your judgment be confirmed after the possession credit at $3,844.37, correct?
Yes.
And at this time, we are requesting that you be ordered to pay. Is that right?
Yes.
But that there would not be an actual payout amount set at this time. Is that correct?
Yes.
And the reason for that is because there is some money on hold regarding the funds that you have paid, correct?
Yes. And as I said, I had received letters myself saying I was in the red.
Yes. And at this time, it's just that money has not been applied yet to the arrears, correct?
Correct.
Okay. And sir, regarding the, what are you asking the court to do regarding the current child support that you're ordered to pay?
She have a child, I have a child.
So regarding the child support, what are you asking the court to do regarding your child support obligation?
The drop child support for me, for Chloe, you know,
Okay.
I have the possession of color.
Okay. And at this time, you haven't filed any pleadings requesting child support from Miss Mark for Cullen. Is that right?
None of the above.
Do you have any intentions of requesting child support from Miss Mark?
No, ma'am. No,
Okay.
no, ma'am.
So at this time, you're asking the court to terminate your child support obligation
Correct.
as of today.
Yes, ma'am.
Okay. And so you understand that this case has incurred court costs. Is that right?
Yes, ma'am.
And you're just asking the court to allocate those appropriately to either you or Miss Mark. Is that right?
Yes.
Okay. Your Honor, with that, I have nothing further. I pass this witness.
Okay. So does the state have any requests regarding the court costs?
Your Honor, at this time, since neither child is receiving any state benefits, seems that Mr. Boykins has had the kids on private health insurance. If they can be allocated appropriately, whatever the judge decides. I don't have a position on the allocation of the court costs, Your Honor. at
Okay,
this time.
bear with me while I look it up. I thought I was limited to I can't order them against a recipient of services. It sounds like they both might be recipients of services.
And Judge, if I may say, if the court does deny the allocation of the court costs to any of the parties, I mean, I have no position regarding, I just would like it to be addressed.
Yes, ma'am. As well, I'm saying anything of my that's remaining, I'm just saying that come back toward to me. That's a question.
And Mr. Boykins, there's no question on the floor for you at this time, sir.
Oh,
Yes, sir.
apologize.
Okay. Mr. Boykin, the state doesn't represent you. Is there anything else you'd like to say regarding the hearing?
No, ma'am.
Okay. I'm going to find there's been a material and substantial change in circumstances since the prior order, and that it has been more than 3 years since the prior order. And I'm going to confirm a child support judgment against Mr. Boykins after possession credits in the amount of $3,844.37 as of October 24th of 2023. I'm ordering that judgment against him and ordering that Mr. Boykins pay the judgment. I'm not setting a specific payout. However, it is all due and owing, and the Attorney General's office can collect on it. I am going to order, I'm finding there's one child, I guess, before the court. Well, I'm going to do this. I'm going to order the child support at $0 per month beginning November 1st of 2023. I guess with a step down to 0 as well. With a finding that Ellen is in the possession of Mr. Boykins and Chloe is in the possession of Mr. Boykins. And just to confirm, sir, both of these children are graduating at the end of this year?
Yes, ma'am.
Okay, so we're talking just a few months of support that could even be ordered.
Yes, ma'am.
Okay, I'm going to set it at 0 going forward as well. And I don't believe I have authority to order attorneys or to order fees against anybody because it sounds like everybody has been a recipient of services and I'm not allowed to order fees against recipients of services. So I guess you can say I'm denying or just not ordering anyone to pay the fees.
Yes, Judge.
The Attorney General's office is going to draft an order based on my ruling today, and they'll be sending it to you for you to review and to sign off on it, and then you can ask any questions that you may have about it. But
Yes.
we're going to send
Yes,
you
ma'am.
back to the breakout room where you'll get a chance to do that. Okay? And good luck with everything going forward,
Okay.
sir. Thank you so much for coming in.
Yes, ma'am. Thank you both.
Thank you.
Yes, Judge. Thank you, Judge.
Yes.